I don't know how many of you out there watch Keemstar, but if you do watch Keemstar, you will have noticed that I was on his last episode on his channel. Me and Keemstar were like this.
Another online attorney known as Viva Frei.
That's not how you pronounce my name.
Viva Frei, Montreal litigator turned YouTuber, and if I'm talking a little softer than usual, it's because I've got someone sleeping in the back of the car. This is like the only way to remain productive during these outrageously insane times. I hope everyone out there is doing fine. Don't let the panic overwhelm you, even if it is at times overwhelming. Get rest, get exercise, eat well, take care of yourself, take care of those around you, and together we will get through this. But just to distract you from what's going on out there, if only for the next 12 to 14 minutes, let's talk about Keemstar. Let's talk about this tattoo artist, Nicko Lacoste, and let's talk about the otherwise sound advice of remaining quiet when there is pending or potential litigation. It is something that I've been saying since the Twitter world somehow overlapped with the practice of law, and we saw a great number of lawyers taking their clients' disputes to the Twitterverse. We see litigants taking their legal battles to Twitter, and you don't have to be a rocket scientist or a rocket scientist lawyer to know that it's just a silly idea. More often than not, there's absolutely nothing to be gained by it and only exposure created from it. And within the last week or two, we have seen two perfect examples illustrating why this is the case. Akilah obviously versus Sargon of Akkad, and now Lacoste versus Keemstar. In the Akilah obviously lawsuit versus Sargon of Akkad, while that lawsuit was pending, while Akilah Hughes was suing Carl Benjamin for copyright infringement, she took to Twitter to make all sorts of outlandish statements. She was going to bankrupt Sargon of Akkad, she was going to shut down his Patreon account, she was going to take hundreds of thousands of dollars from him, she was going to send him Christmas gifts which were legal proceedings. De Beers coined the expression that a diamond is forever, but I know a ton of people who have lost diamonds. It's not a diamond is forever, a tweet is forever. You can lose a diamond in a heartbeat. You can never permanently delete a tweet. Once you put something out there into the interwebs, it is out there forever, no matter how hard you try to squeeze that toothpaste back into the tube. And in the Akilah Hughes versus Sargon of Akkad lawsuit, those tweets are coming back to haunt Akilah Hughes currently. Sargon of Akkad, having won the copyright claim against Akilah Hughes, is now seeking his legal fees from her, and he is using those tweets as evidence of her bad motivation in the context of that lawsuit. In law, and even in the absence of those tweets, Sargon of Akkad would still have an argument to reclaim his legal fees from Akilah Hughes. There's a provision of law that provides for it specifically. But in the absence of those tweets, Sargon of Akkad's arguments would have been that much weaker. The court might have been that much more sensitive to Akilah Hughes. They might have been more inclined to give her the benefit of the doubt had there not been years of evidence of actual malice. Now, true, as at the moment of filming this, the court has not yet rendered its decision on Sargon of Akkad's motion to reclaim legal fees, but I have predicted that he's going to get his legal fees in full. And I make that prediction not only on the basis of Akilah Hughes' tweets, but on the basis of those tweets in the context of what the court told her at that pre-trial conference. Incidentally, if you haven't seen my videos on the Sargon of Akkad legal situation, I'll post a playlist right there. Nothing good comes of tweets making public statements of a lawsuit while that lawsuit is pending. Some might argue that by making tweets and bringing a lawsuit to social media, you are raising awareness of the lawsuit. True. But going to social media to raise awareness of the existence of the lawsuit is different than litigating that lawsuit in social media. Which brings us back to the Nicko Lacoste lawsuit against Keemstar, and that is my male person right there, which brings us back to the Nicko Lacoste lawsuit against Keemstar for $3.5 million. Now, for those of you who don't know, Nicko Lacoste is apparently a very famous and talented tattoo artist in California. Apparently he has tattooed a bunch of very famous celebrities, and he's extremely well known in the tattoo industry. Well, apparently he also got involved in what is being described as sexually charged tweets with underage individuals. Being a celebrity and this being newsworthy to some, I guess Daniel Keemstar Keem, the host of Drama Alert, did a few videos on the subject. He talked about the scandal, he talked about Nicko apparently sexting minors, and can you believe we live in an era where there has been a word created of sexting?
Sexual texting.
It's crazy. Apparently Nicko either live streamed or sent video of his private parts to the minor. That minor subsequently gave that video to Keemstar, who did a video on it and an interview with that minor. And in one or more of the videos on the subject, Keemstar referred to Nicko as the P word. Now, I just did a vlog breaking down Nicko's lawsuit against Keemstar. I'll link that video right here. And for those of you who don't know what the P word is, it rhymes with potato trial. Now, I don't know what public statements Nicko has made since having filed the lawsuit, but everything I'm about to say now applies equally after the lawsuit has been filed and as of the moment you likely think you might have to sue somebody, or as of the moment you think that you are likely to get sued. As of the moment that the probability of a lawsuit is relatively increased, you are just better off being quiet on the public sphere. And this applies as much in civil litigation as it does in criminal matters. Once there is a sufficiently high likelihood of a civil lawsuit or criminal proceedings, just be quiet. I put this in a manner that is somewhat more polite than the other YouTube lawyers who did a hilarious video on shutting the whatever, I'll just post a clip right now.
Mark and Craig, Pot Brothers at Law. We've been warning people, if you are working for an unlicensed dispensary, an illegal dispensary, and it gets raided, you need to shut the f*** up.
In fact, I would argue that it's almost more important to be quiet as of the moment you think a lawsuit is likely, because you don't have a lawyer at that time who can tell you what to say and what not to say. And once you start taking battles to social media, there are certain bells that cannot be unrung. In the context of the Nicko Lacoste lawsuit against Keemstar, before that lawsuit was filed, Nicko actually went on Keemstar's Drama Alert to do a live stream interview with Keemstar. You do not need to be a Supreme Court justice to know that that was a silly... Is my vlog time over? You still want to sleep?
No.
Okay, I'll take you in. You do not need to be a rocket scientist or even a lawyer for that matter to know why that was a bad idea. Every public statement that Nicko makes on the subject can either be used as an admission or a point of contradiction in future examinations in the context of that lawsuit. It can be used as an admission in the context of criminal proceedings. I once did a live stream with Phil Damaris, and if you don't know who Phil Damaris is, he is being sued by Marineland and counterclaiming against Marineland. I did a couple of videos on his lawsuit, I'll link those right here. But my main concern when doing that live stream with him is that the lawsuit was currently pending. I knew with certainty that the attorneys for Marineland would be watching that live stream and waiting to pounce on any admission that Phil Damaris made in the context of that live stream. Long story short, Phil was well aware of the risks and knew sure as sugar that the attorneys for Marineland were watching that live stream waiting for him to say something that they could use against him in the court of law. Nicko Lacoste goes on Drama Alert to do a live stream with Keem, and the answers he gave to some of the questions can only come back to haunt him.
Are you guilty of these things?
I want to say that some are real and some are fabricated.
Well, were you sexting with 14 and 15-year-old girls?
Well, here's the thing. So
there was literally nothing for Nicko to gain by doing that live stream with Keemstar, and if Nicko had the slightest inkling that he might be suing Keemstar at a later date, it was probably the silliest thing for him to do. Not just that, given the potential for a criminal complaint against Nicko, it was possibly the silliest thing to do. In that live stream, while there was literally virtually nothing that Nicko could have done to help himself, there was so much that he could have done to harm himself. Admissions of potential criminal conduct, statements that will come back to bite him in the butt in cross-examination in his lawsuit, and this actually brings me to some of the allegations made by Nicko in his lawsuit against Keemstar. In his lawsuit against Keemstar, Nicko does in fact make what we refer to in law as judicial admissions. Nicko admits that the individual that he was having sexually charged conversations with was in fact a minor. Now, for the love of all that is legal, I don't understand how an attorney makes that type of judicial admission for and on behalf of their client in a lawsuit. I cannot think of any plausible advantage for having made that type of admission in a lawsuit, so I can only chalk it up to being a very, very big mistake. And it is a mistake that will be very difficult to undo. Now, I don't know the exact rules of procedure in California as far as amendments go, but at the very least in Quebec, you can pretty much always amend your proceedings as you deem fit. You can amend your proceedings by adding allegations, and you can amend your proceedings by striking allegations. That being said, any attorney that is worth their weight in salt will not let an opposing party strike an allegation that was in fact a highly prejudicial judicial admission. So even now, even if Nicko comes in and tries to amend or strike that allegation, if I'm the other party, I'm saying, no, 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 I oppose this amendment, leave that judicial admission in there, because I'm going to hold it against you. For those of you who have been around my channel long enough, you know that I frequently say draft everything as though a judge is going to read it. When you speak to your adversary, speak as though they are recording the conversation, waiting for you to say something that they can hold against you. Now, this is easier said than done, because sometimes even when you draft something thinking or knowing that a judge is going to read it, you don't know how that judge is going to read it in the future. Situations evolve such that what you thought was safe to have said in the past might not be safe in the future. And the perfect example of this, had Akilah Hughes won her lawsuit, her tweets would not have come back to haunt her. She thought she was going to win, so she thought it would be safe to make those tweets, even if a judge read them in the future. And had she won, she probably would have been right. A judge reading those tweets after having concluded that what Sargon of Akkad did was copyright infringement would read those tweets much differently than a judge who just said it's quintessential fair use now reading those tweets. And because it is so hard to predict the future and be sure that what was safe to say in the present will be safe to say in the future, you are better off just saying nothing. Say nothing except that which you need to say, because chances are the more you say that can be held against you. When it comes to litigation, less is more is the rule, not the exception. Both Akilah Hughes and Sargon of Akkad made their respective beds, and their respective beds were very different to sleep in. And when it comes to Nicko versus Keemstar, it seems like Nicko is making a very Akilah-like bed. Keemstar, for his part, is definitely not going the way of Sargon of Akkad, because he is being very vocal about this lawsuit as it's pending. But on its face, it looks like this is going to be a very difficult lawsuit for Keemstar to say something terrible that would sink his position. Difficult but not impossible, but I am sure Keemstar is well aware of the risks, and I'm sure that he has other reasons for publicizing this lawsuit. And one last thing when it comes to that judicial admission made by Nicko in his lawsuit. When it comes to certain types of crimes, specifically statutory crimes, it doesn't matter if the accused didn't know that the victim was underage. And so while it's conceivable for Nicko himself to have thought that it was a valid defense to say, I didn't know that the individual was a minor, that is much less reasonable for a lawyer.
Plaintiff was engaging in the sexually charged conversation. Then he goes on to say the individual was a minor.
Wait, he wrote that in his own complaint.
In there. This is the time that you shut the fuck up on paper, off of paper. You shut the fuck up. It's just absolutely ridiculous, and that's the fucking tip of the day.
So above and beyond what Nicko said prior to filing proceedings, the fact that it's an admission in those proceedings really eliminates many of the arguments that Nicko might have otherwise had. It is a judicial admission of Nicko's knowledge of material facts, and the only way I could see this mess sort of being unmade is by a motion to disavow the admission made by the attorney. In which case, assuming that it's sort of the similar procedure as in Quebec, Nicko would have to turn against his attorney, say that I never authorized my attorney to make that judicial admission, get that attorney out of the file, find a new attorney to come into the file and try to clean up this big mess. Alright, this is a highly fluid situation and a story that I will be following to the end. I promise you that much, and with any luck, maybe I will get to do a live stream with Keemstar to talk about it. In the interim, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, and feed the algorithm. Support links you can find as the pinned comment in older vlogs. Going forward, we're going to change things up a bit for the foreseeable future. I am going to pin highly worthy comments to the pinned comment in all future videos. In the meantime, be well, deep breaths, eat well, exercise, get good rest, keep in touch with friends and family, and now you know you vlog. Peace out. Alright, and because this video is not yet 12 minutes long, let's just get some filler. What are you doing?
This is the part when there were skeletons.
What movie are you watching?
Jack and Jack.
Captain Jack Sparrow, okay.
Hey, yeah, you didn't ask me.
What are you doing?
I'm cleaning our license plate. We just got a new car, and I cleaned our old license plate.
We got a Subaru Ascent, actually cheaper than our Ford Explorer, which is very convenient. And how are you doing? Do you have any advice for the interwebs?
I'm hiding. Advice, do what you can. Peace out.